Welcome, everyone. Good afternoon. My name is Grant Campbell. I'm a partner and head of the Brodies commercial law team. Welcome to what we intend will be the first in a regular series of biannual webinars talking about hot topics and significant developments that are relevant to anyone who has a role which involves commercial contracts or other commercial activity. I'm going to be joined by 4 other speakers who are all experts in their field, and I will introduce them briefly. So Alison Bryce, my partners, and Andy Nolan, Jamie Dunn and Rebecca Taylor. So the topics that we're going to cover today. So Alison is going to talk about the CrowdStrike and the Microsoft Global outage. I will talk about developments in AI, everyone's hot topic. Jamie Dunn will talk about procurement reform. Rebecca Taylor will talk about the Digital Markets Competition and Consumer Act 2024. And Andy finally will round off with a commercial case law digest. And as I said, if we have time, we will take questions at the end. So first up is Alison, who's going to take us back to the long hot summer in July and the Microsoft Global outage. Alison.
Well, funny you should say that, Grant, because this kind of strikes fear into my heart, this issue, because I was sitting in a lovely warm beach in Mexico when CrowdStrike hit, and my phone started pinging to say that there's been all these IT issues around the world. And I thought, oh, that's all very interesting. I'm going to enjoy them from afar, until I realized that it was potentially impacting my flight back home 2 days later. And then it turned from, quite a bad IT incident to quite a lot of drama in my life. But anyway, obviously got home. So what actually happened when CrowdStrike hit? So essentially, it was an IT outage that started in the early hours of a Friday morning in Australia, and then very, very quickly spread across the globe through Asia, Europe, and eventually hitting the Americas. It first manifested, and it became quite known for the kind of blue screen of death. So if you had the blue screen of death, which signals a fatal error in a Windows PC, then you knew you were going to be impacted by it. That led everybody to think perhaps it was a Microsoft issue. It didn't take much investigation to realize that the problem was actually caused by a cybersecurity company called CrowdStrike. Now, CrowdStrike had just been trying to do a very routine update and fix to a type of proprietary software called Falcon. It was a cybersecurity software used by many, and it was just a routine update. Essentially, they were just trying to fix a little vulnerability in the system, and instead the update blocked legitimate applications, and chaos ensued. CrowdStrike came out quickly, apologized, took responsibility, but the damage was off and running. I wanted to just flag that this, although they were a cybersecurity company, it wasn't actually a cybersecurity incident at first. So it was just an update, and it didn't operate the way it should, and it caused the subsequent chaos. I say it first because there was a big cybersecurity reaction to this, and that all the bad actors around the globe started taking advantage. And I think what we saw was an increase in spam and malicious zip files that were purporting to offer fixes. There was websites set up which were purporting to fix the issue, domains, lots more phishing attacks. So it wasn't a cybersecurity incident, but it caused subsequent cybersecurity incidents. But let's talk about the money, because what did that all actually cost? And essentially, so 8.5 million Windows devices went down, which actually sounds a lot, but wasn't that many. I mean, it's only 1% of Windows devices that kind of were impacted. And I think really that one of the key issues with the CrowdStrike incident was that the software was used by customer-facing systems. And so I think that 1% was felt much more than, perhaps if it had been a back-end function. So current estimates are that $10 billion have been lost due to this one incident. And just to give a context, because we like a bit of context, 90% of lawyers are Microsoft Word users. We all like our Microsoft Word. And if just 1% of those lawyers were offline for one day, then that's 12,096 unbilled hours that we're not getting charged. I'm going to say that quietly because I can't imagine our managing partner's heart could cope with the impact of that. I mean, and I think it's interesting to look at this incident and think about, well, who actually could potentially claim from this problem that was caused? I mean, the first is the end user. So me trying to get back from Mexico and being unable to actually return. But my claim would be with the airline because it was the airline that wasn't actually providing the subsequent service. The airlines who contracted with CrowdStrike, they could also have a claim and they could possibly claim for the loss that they've suffered. This might include compensation payments, refunds, financial loss that they've suffered. And the claims weren't slow to start. I mean, I think this is where things get quite interesting. So Delta Airlines were first out the block, and they have issued a claim to CrowdStrike for $500 million, which they claim is the loss that they've suffered by their airline being down and the time that was spent. But there's other actions that have started. So, for example, there's a shareholders class action undergoing at the moment, and they're claiming that they had been misled as shareholders as to how the company were actually operating their testing before going live. And I have slight sympathy. I mean, if your share price fell by 32% in 12 days, you might not be happy either. And then there's a number of class actions, particularly in the US, where small businesses have come together and are trying to claim that they've been impacted by the outage. So let's take it back to the law, because I mean, that's what happened. It's all very interesting. But what does the law say about it? Well, the first thing to kind of think about was CrowdStrike a force majeure event? And I think it's worth just making a few observations in relation to force majeure. So, firstly, we all recognize a force majeure as an event which is unforeseen, beyond the control of anybody involved, and leads to a failure to perform the contract. So typically, that's the three criteria that needs to be met. I think one of the things that we certainly saw as lawyers during COVID is that almost no two force majeure clauses are ever drafted the same. So in answer to the question about could the global IT outage be a force majeure, I'm going to give a very lawyerly answer and say, well, it kind of depends. It does. It depends on what your clause says and whether you are covered or not. I would just highlight that it is relatively common to include in a force majeure clause an express reference to interruption or failure of technology utility services. And so my takeaway from this is perhaps we should all be paying a bit more attention to our force majeures than we typically have in the past. The other thing that we should be looking at is our caps and liability. So I've already told you there's a lot of financial loss that's been suffered. Who's actually picking up the pound on that? Well, again, give a lawyerly answer. It depends on the specific contract. CrowdStrike entered into a number of different bespoke contracts with customers. So I'll have a look at their general clauses in a minute, but you will know that most software services like this include within them a cap and liability. And indeed, as lawyers, it's often the last point that we ever get to agree, and it's one that people sometimes, don't focus on as much as they should. So looking at the next slide, this is actually CrowdStrike. I was very pleased to find this. This is actually CrowdStrike's general terms and conditions, and this is what their day-to-day contracts say. Essentially, as you can see from the highlight there, they have excluded consequential loss and they've sought to limit their liability. That's fairly normal in a software contract. But they've also capped any amount that's recoverable to the price paid under the contract. So that's what their general terms contract says. What's actually happening in practice? Well, I think it's worth saying that Delta Airlines are having quite a public spat on the issue. So they've come out and kind of said, don't care what our contract says, you're going to give us $500 million. CrowdStrike have been fairly punchy on the way back and have kind of said, well, first of all, we refer you to your contract, which means you're only due single figures of millions. And secondly, we point to your own failures because a lot of airlines managed to recover themselves a heck of a lot quicker than you. So maybe you should be looking at your own operational governance, which I thought was punchy given the circumstances, but perhaps that's just me. Essentially, when you're looking at caps and liability. For them to be enforceable, they need to be fair. So they can't be inherently unfair. And you would also need to prove, if you were trying to argue that the cap wasn't applicable, that there had been an element of fraud. Add to that, in the CrowdStrike case, that there's jurisdictional variations in relation to caps and liability and how they might be interpreted. So, for example, in the UK, we tend to focus on whether the cap is reasonable. However, in New York, they expressly have provisions that say a cap won't be enforceable if there has been gross negligence or willful misconduct. So sometimes you see that wording even creeping into UK contracts. Suffice to say, and the one thing I think that is consistent generally globally, is the fact that the courts take the view that if there's big businesses involved and big boy commercial entities, then quite frankly, they should have negotiated their terms in the unique set of circumstances, and they should have informed themselves to be aware of the risks. So they've typically been a little bit reluctant to actually get involved. Next slide. I'm not going to talk to you all about regulatory change because there's a lot to get through today, but suffice to say that I think the CrowdStrike case has just been a really good example of what the legislature has been trying to address for a while. I think there's a real concern that a lot of the technologies are becoming very interdependent, and one failure or one cyber attack could actually cause catastrophic consequences. So you may be aware of the Digital Operations Resilience Act, which is actually called DORA, but has nothing to do with cute explorers, but that's been brought in Europe in particular, and for financial institutions, to say that there's now an obligation for them to have good interconnected digital systems that operate well. So it's a type of risk framework. It's coming in the UK. That was confirmed in the King's speech this year. We are getting the Cybersecurity and Resilience Bill. And that follows a pattern. We had the Technology Secretary announcing just a couple of months ago that data centres were now classified as critical national infrastructure. And the previous government, so interesting to see what this government will do, had confirmed that they were also going to implement the Network and Information Systems Directive into the UK, which again essentially says that these systems need to be strengthened. So what does this all mean for you guys as lawyers and as businesses? What do we learn from it? I think the first thing to say is that you should be reviewing your supply chain on a regular basis and just ensuring that they are as robust as they possibly can. And then you should be horizon spotting for looking at any operations that are critical to your delivery. Consider if you're too reliant on one supplier in your supply chain. I saw a statistic that said for cybersecurity, 15 companies globally own 62% of the market share. Now, Rebecca will be talking a little bit about the DMCC later, but certainly that's attempting to target the fact that these digital companies are beginning to be overly dominant in the markets. Look at your force majeure clause. I think it's one that we tend to all overlook a little bit. It's always deemed to be a bit like boilerplate, but be sure that you're excluding things that you are comfortable to exclude and that you're not excluding too much. And my last tip for the top is really pay attention to your cap on liability. We often get asked, well, what's a standard cap in the circumstance? And we can absolutely offer guidance in that, but you have to think about the worst case scenario. Is it going to really cripple the business, bring everything down, and what's your recourse at that time? So I think that was all I wanted to cover. It's a really interesting incident. I could talk for longer, but Grant won't be happy with me, so I'll stop there and I will hand over now to Grant, who's going to talk about artificial intelligence.
Thank you, Alison. Yes, so I'm going to talk a little bit about artificial intelligence, which is a hot topic for everyone. I talk a little bit about the latest developments in the law and actually what they mean for contracting. So we maybe start by looking at the legislative picture. I'm going to start with a bit of EU legislation. Now, it doesn't apply directly into the UK, but it may apply to businesses that are looking to operate by providing or putting AI systems into the market in the EU. But it also may be influential in terms of legislation that appears elsewhere. So the EU AI Act came into force on the 1st of August 2024. It is a very dense and lengthy piece of legislation. But what in essence it does is introduces a risk-based approach to regulation in the EU for AI systems. So there are unacceptable AI systems, which are ones that are deceptive or exploitative, and they're just simply banned. The main the main focus is on high risk AI systems where there is a whole range of measures that are going to be introduced. So high risk systems are specified. They're specified as being ones in an annex at the back of the Act, and they affect key areas such as employment, education, and public services. And there are a range of measures that are applied that under the Act to those high risk AI systems, including registration, data training, governance, technical documentation requirements, record keeping, a whole host of things, and including cyber security. So a range of measures that are applied to high risk AI systems. Limited risk AI systems are ones that actually interact with people directly, and the main requirements there are in terms of transparency so that people know that they are dealing with AI systems if it isn't obvious. And then there is a residual category of minimal risk systems, which are largely left alone. The important point to note in this as well is that there's a stage implementation, and it's quite complex, but there are various dates from next year right the way through to 2027. But I think the key steps for implementation of this Act are between the dates in 2025 and 2027. Now, getting into the detail goes beyond the scope of the limited time we have now, but it is important to be aware that if you are operating with AI, you're using AI, and you're looking to put AI into the EU market, then you may well be caught by this, and you need to be aware of it. And there's a contrast here with the UK approach. So the position of the previous government was a very much pro-innovative AI approach. So they were very much in favour of AI, and they wanted to do a light touch regulation, so sector driven, relying on existing legislation and regulators to take the lead in telling people what they needed to do, depending on what sector you were in. Now, that difference in approach could lead to cross-border compliance issues, because if the UK is taking a markedly different approach from the EU, then there may be issues. But the approach is slightly changing. So the new Labour government has taken a slightly different approach. So next slide, please. So the King's speech following the election of the Labour government suggested that new legislation may well be on the horizon. So there was reference specifically to appropriate legislation to place requirements on those working to develop the most powerful AI models. So that's what was said in the King's speech. Since then, earlier this month, the UK has signed the Council of Europe Framework Convention on AI, and you see there specific reference to human rights, democracy, and the rule of law, which is very much a subject that is close to Keir Starmer's heart. This is not an EU, so the Council of Europe is not part of the EU, but the signatory states are required to implement measures to meet the AI convention requirements. So signatories to this include the EU, but it also includes the US. So the requirement will be to make sure that these convention obligations apply to public authorities, but also to private sector actors. But it's up to national governments to determine how they implement those measures, particularly in the context of private sector actors. So there's a fair degree of uncertainty at the moment as to how this convention will be implemented in the UK. And the convention itself is quite light touch. So it talks about broad principles rather than specific requirements. And there are no strict enforcement criteria. But I think the combination of the King's speech and the UK having signed up to this convention signals a change of approach to the previous Conservative government. But in the meantime, UK regulators are continuing to publish guidance and thought pieces on AI. I've put on the slide a number of links and some of the main regulators, some of the stuff that's been issued by the main regulators, but they have been following the previous government's 5 key principles for regulators. So very briefly, they are safety, security, and robustness, appropriate transparency and explainability, fairness, accountability and governance, and contestability and redress, so giving people the right to challenge the decisions that are being made. So that's kind of where we are in terms of the legislative backdrop and the regulatory approach. There have been a number of cases. We start to see a number of cases coming through in the UK. First one is about IP. So the UK Court of Appeal has said that artificial neural networks, despite their complexity, so this is a core part of complex AI, are going to be treated as computer programs as such, and therefore they are not capable of being patented under current UK law unless they demonstrate a significant technical contribution. So that's a bit of a blow for AI companies, because it suggests that actually they're going to have to rely on things like copyright rather than patents to protect the innovation that they are building in to their AI models. The other two cases that are flagged on screen are really are highlighting, I think, an emerging battle between AI and the creative industries. So both of these cases are around data scraping. So in the case of Getty Images is an ongoing case where Getty are claiming that Stability AI, which has AI that creates digital images, has scraped a lot of data from its website, and in doing so has infringed its IP. That's an ongoing case, and I think if Getty Images are successful, then actually we may see some significant reforms to UK copyright law to try and ensure that IP rights do not stifle the ongoing development of AI. But that's a very controversial position, so it'll be interesting to see what the UK government does. And more recently, we've seen publicity from Mumsnet, who are saying that OpenAI's ChatGPT has been scraping data off its website and its chat rooms, and that's infringing its IP. So it's going to be interesting to see where those battles end up, and ultimately whether the UK government decides that it needs to legislatively intervene to create a stable and clear backdrop for AI to operate. Next slide, please. So having covered kind of case law and a little bit of the legislative backdrop to this, I wanted to talk a little bit about contracting considerations. So more generally, I think due diligence is key. So if you're contracting to purchase AI, you need to have clear understanding of what it is you're buying. So that comes down to having appropriate due diligence questionnaires, understanding and trying to get minimum documentation sets to understand what AI you're looking at. Also recognizing that actually there may be a number of players in an AI supply chain. So actually don't just think about the person that you're contracting with. You may need to understand what the other players are doing and how they're contributing. And having a clear responsibility matrix set up within your organization so that actually you're looking at what you're buying from all angles and everyone within your organization knows their role. Key risk areas, well, from what we've just looked at in terms of the cases, I think ownership of the data and AI output. So in terms of inputs, what is the provenance of training data? Where does it come from? Has it been harvested in a way that's clearly not going to infringe anybody else's rights? Who's going to own the output of the AI tool that you're buying? And you need to just be clear in your contracts as to what the expectation is. In terms of IP infringement, who is liable? I mean, ultimately, again, it's a case of being clear in your contracts. Don't leave it to general law, because you may inadvertently assume responsibility for IP infringement that you had no control over. Data protection compliance, if you've got personal data involved in the models that you're creating. The basic position is that data protection rules apply to AI in the same way as any other software. So understand and document the data protection relationships that are being created and the basis for processing the data. If you're conducting a DPIA, and I suspect you will be, then these should inform the issues and risks. So that can be a very useful exercise in terms of working out what you will need to put into your contracts. Suppliers are increasingly looking to retain the data for the benefit of their own AI systems for training, marketing, and use with other customers. So again, this comes down to purpose limitation under data protection laws. So why have you got the data? What have individuals been told? How are you going to address that? And I think be wary of free-to-use versions of generative AI. Do not put personal data or sensitive business information in just generally available AI systems. Appreciate here that we're looking at contractual terms that a customer might want to see in a bespoke contract. So if you're just taking general AI from a large LLM like OpenAI, you're not going to be able to influence contract terms. But actually, if you are procuring AI from someone where you do have enough leverage to actually influence the terms, you can use this as a sort of checklist for the things that you would expect to see in a contract. So clearly, the subject matter is key. In terms of defining what you're buying, the AI system, I mean, it's going to be a combination of software and data, but you want to specify where it's to be deployed. Is it on-prem? Is it in the cloud? What security standards, etc., will apply. The specification for the AI system, the difference here is that with AI systems, they tend to be probabilistic. They're not computational. So actually, you need to be very, very clear what your customer requirements are. And want to be very clear about what the measurable outputs and benchmarks are for what you will get from the AI system. When you're acquiring AI, you're likely to be acquiring a host of services that are bundled in. So in terms of training data, whose responsibility is to provide it? I mentioned earlier the provenance of the data. You want to cover things like accuracy and the right to use it. Development services, so there'll be processes for refining the AI. You're going to be using a sandbox. What are the provisions around acceptance? There'll be ongoing monitoring of the AI as it's deployed. You have maintenance, upgrades, and support. Training and user manuals, and you may want termination assistance when the contract comes to an end. Then actually, what is the expectation in terms of being able to move to somewhere else? You'll expect customer obligations and dependencies. So what is it you have to do as a customer? What dependencies are there in terms of what the supplier will do? Governance is key. There will be governance requirements. So I mentioned earlier about internal governance requirements with customer, but obviously there will be a lot of discussions between supplier and customer as well. Knowledge transfer and transparency. So again, this goes back to what I mentioned in terms of the regulatory approach, particularly by the ICO. The customer should be provided with information that allows it to understand how the system actually works. And this is the concept of explainability. And there should be requirements on the supplier to keep records and to undergo audits. Standards and warranties. So there should be warranties at the outset and on an ongoing basis. So you would expect the AI to comply with its specification. You would expect to have warranties around non-infringement of IP, compliance with data protection law, things like unlawful discrimination or bias. So you want to make sure that actually your model is not going to be discriminatory or biased. Compliance with good industry practice, but I think when you put those sorts of provisions into an AI contract, you need to be very, very clear exactly what you mean. And ongoing compliance with applicable law. So we can see an emerging legislative trend. So who's responsible for compliance and at whose cost? And that's where things like change control provisions in a contract may be very important. IP, so the underlying data and outputs, the materials that are being provided by both sides, the bespoke software that's being created, who is to own these things? If subcontractors are being involved, if there's a supply chain, then you need to ensure that the requirements of the main contract flow those down. Is open source being included? If open source is included, then you need to be aware of IP contamination issues. Source code escrow, is it required? And then when you've got third-party software, and just more generally, you need to have appropriate licensing provisions in there. and prohibitions potentially on use of data, which goes back to the point I made about suppliers looking to use data for ongoing development of their products. And you will also probably want to have indemnity provisions in case of IP infringement claims from third parties. Termination, you want to set out your termination events and the consequences, and actually think about when the contract comes to an end or you want to move on, then actually what runoff rights are needed and what support will you need from the supplier to move to someone else. So that was a whistle-stop tour of what I wanted to say. Over to Jamie, who's going to talk about procurement reform. Jamie.
Thanks, Grant. So hopefully it will be of no surprise to most of you that there is a new UK public procurement regime, which is to say the Procurement Act 2023 that was due to come into effect on the 28th of October. It's now due to be commenced on the 25th of February next year, so 2025. And what that will do is give us a slightly more complicated public procurement landscape, the procurement rules that public sector buyers have to comply with when they are choosing who is going to supply them. So for contracting authorities outside Scotland, think pretty much anybody buying something in England or Wales or Northern Ireland, then they will be subject to the Procurement Act 2023 and the Procurement Regs 2024, and obviously the place to litigate that will be wherever they are, the courts of wherever they are buying. However, rest of UK contracting authorities who are buying in Scotland, so UK government bodies or a lot of UK-wide bodies, when purchasing in Scotland, will also be subject to the Procurement Act 2023, the 2024 regs, except the only difference really is in those circumstances, there will be a job for the Scottish courts to enforce those. For devolved Scottish contracting authorities, so think Scottish Government or local government in Scotland, Scottish Quangos, they will remain subject to the existing procurement rules that we have in Scotland. So nothing really will change there in the immediate term. And for regulated health procurements, there's yet another complicating factor. Certain NHS buyers, in particular in England, will have to comply instead of with the Procurement Act, with instead the Healthcare Services Regulations 2023, and those will be subject to different enforcement. So really where this leaves us is for public bodies, which part of this landscape they are going to have to live in will depend on who they are and where they are when they are carrying out their buying activity. But for suppliers, from a supplier's perspective, you may well have to grapple with more than one of these, particularly if you operate across the UK. But even if you are only operating in Scotland but selling to both devolved and UK level buyers. So the focus today of my contribution to this update is the Procurement Act and the features of that you need to be aware of. So very quickly, just as a reminder of who is subject as a buyer to the Procurement Act 2023. This looks very similar to the existing procurement rules that those of you that are selling to the public sector will know and love. Public authority is defined in much the same way. But for utilities contracts, the Act will apply to public authorities and public undertakings and private utilities. Again, very similar to the old utilities regs. Who is a public authority? Basically, anybody that's wholly or mainly funded out of public funds or is subject to oversight by a public authority and does not operate on a commercial basis. You think about any obvious public body, but also arm's length organisations that are owned or controlled by public bodies but aren't undertaking commercial activities. So they will constitute public authorities for this purpose. Public undertakings are the same thing, but where they are operating on a commercial basis. So commercial arm's length organisations that are controlled by the public sector. And then private utilities are basically those that are engaged in utility activities but aren't one of public authorities or public undertakings. So those are your class of buyers, really, who will be subject to the new procurement rules in the Act. Those are the types of people that you may be supplying to, where you need to be aware of what the Procurement Act changes. There are exceptions to people that would otherwise fall under those. MI5, MI6 are the big ones, but also excluded authorities are any devolved Scottish authority. So this is why Scottish public procurement rules continue to apply in the same way as they always have done. And a devolved Scottish authority is basically any any public body that's only operating in or as regards Scotland and is operating in devolved areas, even if they also do something in reserved areas. And anybody that's subject to public authority oversight only by devolved authorities is also exempted from this. Key point to take away is that if you are operating in Scotland, who is selling in Scotland, engaging with people in contracts in Scotland, then which set of rules they are subject to will vary depending on where they are located, where they carry out their activities, but also what activities they are carrying out. There is an exception to the exception to be aware of, which is that even devolved Scottish authorities who are not ordinarily subject to the Procurement Act 2023 will be subject to it where they are buying things under UK level arrangements. So if a Scottish local authority buys something with an English local authority, then both of them may be subject to the Procurement Act insofar as that procurement and the contracts coming out of it are concerned. The same with any Scottish authority that buys from a UK level framework or a UK level, what's now called a dynamic market, what used to be a dynamic purchasing system. So where Scottish authorities are engaging at a UK level, they may become subject to the Procurement Act. Now, the reason that this matters, if we move on to the next slide, a lot of the rules around supplier selection are going to look very similar to the existing procurement regime. So the rules about how a public body picks who it contracts with are going to be very similar. There are different procedures. Some of them are more flexible, and some of them are maybe sort of less difficult for public authorities to comply with in some circumstances. There are some changes. In particular, you probably want to be aware of the central debarment register. So rather than each individual authority deciding on who to exclude from its procurements, they will still be able to do that to a degree, but there will also be a central list of effectively those companies that are banned from supplying the public sector anywhere in the UK. You don't want to be on that. If you do end up on that, you probably want to challenge being on that because that will pretty much rule you out of everything. The big differences, though, that I want to mention today are those in transparency and contract management. So it used to be really the procurement rules were about how you pick who supplies you as a public body. And once you've done that, subject to certain restrictions, you were pretty much free of the limits of procurement law. There is a lot more now that is full life cycle under the Procurement Act. There are a lot more obligations that carry on throughout the contract, and really the ones to be aware of are around transparency and contract management. So in terms of notices, there is a lot more of a requirement on the public sector and public sector buyers to be transparent and publish notices pretty much every time they sneeze. So we start with pipeline notices. So bigger buyers, those with annual contracts above a certain value, will need to publish a list every year of all of the procurements they're planning above £2 million in the year ahead. There are similar rules in Scotland around construction contracts already, but this is going to be obviously at a UK level, but it's also going to be a lot broader and cover services and goods contracts as well. Tender notices, I mean, nothing unusual about that. You already have notices when a public body goes out to tender, but that is one of the classes of notice under the new rules. Contract details notices are broader than they were before, and this is setting out basically who has got the contract, details of any options and renewals in the contract, and KPIs. And I'm going to come back to the KPI point in a moment. Procurement termination notices, a public body is going to have to publish a notice when it decides halfway through a procurement to stop it. So even if you are not involved in bidding for something, you will be able to see when the bidding on that has been discontinued. There is an obligation on a public body to publish the entire contract if it is worth £5 million or more. So that's subject to certain rules on redactions, but the key point to be aware of is if you sign a contract worth more than £5 million with a public body, then you can expect that contract to be put up online for anybody to see, subject only to redaction of commercially sensitive details. Payment compliance notices. Public bodies are going to have to put notices out on how good they are at paying bills on time. The idea of that really being to name and shame those that don't. Contract performance notices. So there is an obligation on those £5 million plus contracts on a public body to set at least 3 KPIs. And so where the duty on the public body to set KPIs applies, it is then subject to a duty to publish an annual contract performance notice saying how well a contractor is doing against those KPIs. So again, if you have a contract with a public body that's worth more than £5 million, you can expect it to include at least 3 KPIs because it has to, and you can expect a public report every year on how you're performing against those. Contract change notices, modifications to existing public contracts. Some of those historically have gone under the radar. That will be a lot more difficult going forward because there's a much bigger obligation on a public body to publish a notice every time it changes anything under an existing contract rather than going back out to market. And then contract termination notices, where contracts with a public body is terminated, the public body is now going to have to publish a notice. And if it's been terminated for cause, if there has been some breach or failure to perform by the contractor, then again, you can expect a report issued by the public sector, issued by the public body to set out that the contract was terminated and details of what it was that you failed to do that led to it being terminated. So again, something to be aware of in terms of that publicity. And then in terms of implied terms, just to zoom through these, an authority must accept and process electronic invoices. It must pay any valid invoice that is not disputed within 30 days or later if that's when the date on which the payment falls due, and may only rely to payment to a third party with the agreement of the payee. Now, one point to be aware of is this doesn't just apply to contracts between the public sector and suppliers, but between suppliers and their own subcontractors. So if you are a lead supplier, then this is going to be implied into your contracts with subcontractors. And if you're a subcontractor, it's going to be implied into the contract you have with the prime contractor. The same terms are also implied into certain below threshold contracts, lower value ones. Key point, you cannot contract out of this. It's not just implied, it's required. So these terms are going to be in those contracts, whether you like it or not. There's also an implied right for the authority to terminate the contract if a certain termination ground applies. Really, that arises where your company is convicted of certain criminal offences. At that point, the public body will have a right to terminate an existing contract. And then finally, in addition to your ability to pursue public bodies through the courts for breaching these rules, there are going to be additional remedies, effectively, in particular, an ability to complain to a new public procurement review service if you're unhappy about the way that public bodies are handling specific improvements or if they're paying you late. And there is also going to be a procurement compliance service to investigate systemic problems, and a debarment review service. To go back to the point I said about the central debarment register, if you find yourself on that, get in touch with the debarment review service if you want to challenge it. So that's a quick speed through the new procurement rules, and I will hand over to Rebecca to talk about the DMCCA.
Thanks very much, Jamie. So the Digital Markets Competition and Consumers Act, commonly referred to as the DMCC, received royal assent in May this year and marks the most significant reform to UK competition and consumer protection law in decades. So if we just move on to the next slide. The UK has now become the 4th jurisdiction to pass digital regulatory legislation, and which targets tech giants, joining the EU, Germany and Japan, with several other countries also indicating that they're going to introduce similar legislation. The Act gives the UK's competition regulator, the Competition and Markets Authority, the CMA, tools to stop technology businesses with strategic power from misusing their position to disadvantage competitors and consumers. The law will also create penalties for traders that break consumer protection laws and allow the CMA to enforce consumer law directly. So under the new rules, it will be easier for consumers to manage their subscriptions by providing clearer pricing, banning fake reviews, and giving consumers greater control over what they are purchasing online. The Act requires businesses to provide clearer information to consumers before they enter into a subscription contract, such as reminding consumers that their free trials and low-cost trials are coming to an end, and ensure that consumers can easily exit a contract. Unavoidable hidden fees will also need to be included in the initial costs or clearly illustrated at the start of the purchasing journey. This will ensure that consumers are clear from the offset about exactly what they're going to be spending. So on the next slide, we've set out the timeline for implementation of the Act, and you'll see that it's going to be introduced in a number of phases. And while, of course, there are a number of topics that we could cover during this session today, including the impact on competition, we'll focus here on the provisions which affect consumers and will be important to note for your future contract drafting. So looking at the next slide, the impact of the Act on consumers, today we're going to focus on, firstly, unfair trading and secondly, consumer contracts. So the Act repeals the Consumer Protection from Unfair Trading Regulations 2008 and reinstates them with some amendments. In particular, it introduces more detailed provisions to address drip pricing and practices relating to fake reviews, as I've mentioned. So there are now going to be provisions which address drip pricing, which is the practice of adding further non-optional charges to the initial price during the purchase process. So under the Act, any invitation to purchase must feature a total price, which includes any non-optional costs such as booking fees. And if any element of the cost cannot be calculated in advance, then information about them and how they will be calculated must be given to the consumer alongside the price. Schedule 20 of the Act lists the commercial practices that are automatically considered unfair in all circumstances, and we've set some of them out on the screen here. And therefore, if any trader was to carry out any of these commercial practices, they open themselves up to being sanctioned by the CMA. So some examples of the commercial practices listed here include displaying a trust mark, quality mark, or equivalent without having obtained the necessary authorization, falsely stating that a product will only be only available for a limited time, or that it will only be available on particular terms for a limited time in order to elicit an immediate decision and therefore deprive consumers of sufficient opportunity or time to make an informed choice. It also includes submitting or commissioning another person to write a fake consumer review or a consumer review that conceals the fact that it has been incentivized. So a fake review is defined within the Act as a consumer review that purports to be but is not based on a person's genuine experience. So under section 237 of the Act, the trader will have committed an offence if they have engaged in any of these commercial practices, which is unfair by virtue of it being listed in this Schedule 20. The Secretary of State also has powers under the Act to amend the Schedule 20, so they can add, amend or remove various commercial practices. The Act also sets out the penalties for breaching this Schedule 20, which includes a fine or imprisonment for up to 2 years or potentially both. So moving on to the next one. Firstly, what is a subscription contract? Well, it is defined in the Act as a contract between a trader and a consumer for the supply of goods, services, or digital content by the trader to the consumer in exchange for payment, which also meets additional requirements set out in the Act. For example, that it is a contract which automatically recurs or continues until such time as the consumer brings it to an end. So Part 4 of this Act also provides consumers with significant new rights in relation to their subscription contracts. And for these contracts, the Act replaces the main parts of the Consumer Contracts, Information, Cancellation and Additional Charges Regulations 2013 on pre-contract information and cooling off cancellation rights, and now provides tailored provisions specific to subscription contracts. So as an example, businesses will now need to give consumers pre-contract information about the subscription and confirm it on a durable medium post-contract. They will also be required to send consumers renewal reminders at specific intervals. The Act also sets out the information that has to be provided within these renewal reminders, for example, the relevant date that it will renew and what the consumer will then be liable to pay. It also must provide simple mechanisms for termination and give consumers cooling off rights on entry into the contract, expiry of the introductory period, if that's applicable, and also on any renewal which commits the consumer to a period of 12 months or more. So now looking at enforcement, there will now be two regimes to enforce consumer protection laws. So firstly, the ordinary route via the courts, and secondly, direct enforcement operated by the CMA. So direct enforcement powers will now be given to the CMA under the Act, who will have the ability to investigate and sanction businesses that breach the consumer protection laws. This is, of course, a significant shift from the current position where consumers and regulators must go through a lengthy and expensive court process to achieve a resolution. The CMA's first enforcement step will be to start an investigation and thereafter to issue a provisional infringement notice, requiring a trader to stop infringing the particular consumer protection law. Where the provisional infringement notice is not complied with, the CMA can then issue a final infringement notice, requiring compliance and imposing a fine of up to 10% of turnover or £300,000 if higher. Alternatively, instead of issuing an infringement notice, the CMA may elect to accept undertakings from the trader and to enforce any breach of such an undertaking by imposing fines of a fixed amount of up to 5% of turnover or £150,000 if higher. Additionally, a daily penalty of up to 5% of daily turnover or £15,000 if higher can be imposed. The CMA also has the right to require enhanced consumer measures to provisional and final infringement notices where it's considered just and reasonable, such as taking redress measures. The CMA may also take enforcement actions against directors of businesses who have control over the business and have consented to the infringement. The CMA's direct enforcement powers will sit alongside the court enforcement regime, which allows the same remedies to be imposed by the courts or for the courts to hear appeals from the CMA penalties. So in summary, then, what is next? Well, the CMA have informally indicated that they will publish guidance on the new rules in late 2024 or early 2025. And it's, of course, important that businesses carefully consider the impact this Act may have on its approach to consumer protection, and in particular, its marketing and advertising approach, as well as its contracts and communications with its customers. So I'll now hand over to Andy, who's going to provide an update on a recent case law.
Thanks, Rebecca, and hi everyone. Conscious of time, so I'll be as quick as I can. There are three cases I'm going to discuss with you today. Each of them have got clear themes and takeaways, which are firstly the importance of proper drafting in a contract to capture exactly what was agreed and intended by everyone. Secondly, that inaccurate or vague language can lead to unintended consequences. And thirdly, that a court will only seek to enforce the clear terms of a contract and won't countenance stepping away from strict contractual performance or adherence to the contract when a party tries, for example, to work around challenging situations that might trigger, for example, a force majeure event. So the first case we're going to look at is, if you could go back one, which is the RTI Mer shipping case. So what was the case? What was the context of the dispute? So Mer is a shipping company. Mer entered into an agreement with RTI to transport goods. RTI was ultimately deemed to be controlled by a Russian oligarch, and this created an issue because of the conflict with Ukraine, because there were international sanctions against Russian-controlled businesses. So under the contract, Mer transported monthly shipments of bauxite from Guinea to Ukraine. RTI paid Mer in US dollars, as was required under the contract. After the US government sanctions kicked in, RTI was unable to make payment to Mer in US dollars. Mer insisted on being paid in US dollars for a variety of reasons, and so they decided to suspend shipments, and they relied on the force majeure clause in the contract, saying that Mer was affected by circumstances outside its control. Under the contract itself, the affected party, in this case it was RTI, they were required to exercise reasonable endeavours to overcome the force majeure event. RTI proposed a practical solution to make payments in euros. Mer rejected this because they said they would suffer wider losses if they were not paid directly in US dollars. RTI insisted that they ought to be able to pay in euros as a workaround, and they were even prepared to make further compensation to Mer Shipping for currency conversion and other losses. Mer did not want to move away from the strict terms of the contract. So the case battled back and forth through the various courts and ended up at the Supreme Court. Supreme Court favoured Mer Shipping's position. They said that there are 3 fundamental legal principles that they wanted to adhere to. Firstly, freedom of contract, underscoring parties' autonomy to set out terms and reject non-contractual performance. Secondly, they said that it was really important to have clear and certain commercial terms. So clear and certain terms are crucial in contract law. A party cannot be compelled to waive contractual rights without explicit language setting the conditions that need to be fulfilled. And thirdly, they said, what's the purpose of a reasonable endeavours clause? It's to provide provisions which aim to maintain contractual performance, not to substitute it with alternative arrangements. So I think we need to remember this. So the object of a reasonable endeavours clause is to maintain contractual performance, and therefore they confirmed the ship owner's argument that absent explicit contractual language, reasonable endeavours clauses do not mandate acceptance of non-contractual performance. So, for example, accepting payment in euros rather than US dollars. So what's the commercial impact for everyone? Well, parties can be confident that compliance with the reasonable endeavours provision and a force majeure clause will not require the acceptance of non-contractual performance, even in circumstances where doing so would mitigate or even neutralise the effects of a force majeure event. Secondly, freedom of contract. The Supreme Court repeatedly said that parties are free to negotiate whatever they want, and a force majeure clause could be constructed to permit alternative ways to fulfil the contract, but it didn't happen in this case. So I think businesses need to ensure the contracts are clear and precise, as courts will prioritise strict compliance over flexibility. Can we move on to the next slide, please? So this case, this is Innovate Pharmaceuticals against University of Portsmouth. So what was the case? What was the context? Case centres around a research agreement between Innovate and the university. The university agreed to carry out research on a drug patented by Innovate. But the issue at hand, well, the research paper that the university produced was allegedly full of errors and was a product of dishonesty. Innovate alleged that it was the fault of the scientist that the university chose to lead the project. So Innovate suffered significant losses of over £20 million, with a large majority of those being loss of profit. So Innovate raised a claim against the university. The research agreement had a limitation of liability clause. So the clause excluded liability for loss of profits of either party. It capped liability for everyone at £1 million with certain exceptions: death, personal injury, and fraudulent misrepresentation. So the university sought to rely on this clause to limit its exposure. Innovate said that the liability cap didn't apply if the alleged breach of contract was committed fraudulently. So it ended up at the High Court. The High Court found the limitation clause was effective to limit the university's liability for dishonest breaches. It said effectively that the fraud itself related to performance of the project, and therefore that was subject to the liability cap. The cap didn't apply to fraudulent misrepresentation. What's that? That's a false statement inducing entry into a contract. So quite a different situation. So things to think about in that case: contractual interpretation highlights the important distinction for commercial parties to be aware that when they're entering into a contract, they should exclude liability for fraud from liability caps. Think about dishonest breaches of contract. How's that captured? And it really just emphasises the need for well-drafted contracts, but also for parties to understand what they're signing up to. And the final slide, please, that I'm going to look at, which is the Leicester City Football Club case. So what happened here? Well, Leicester City was charged by the Premier League for allegedly breaching the profit and sustainability rules. These rules are designed to ensure that clubs operate within their financial means and avoid excessive losses. The Premier League charges related to the 3-year period ending for the season 2023. The central issue in the dispute was whether the Premier League had the jurisdiction to enforce these rules on Leicester City, given the club had been relegated to the EFL Cup. And it all pinned down to what was the accounting date for the accounts to be submitted. Ultimately, Leicester City appealed the case, and it went to the appeal board, and the appeal board came down in Leicester City's favour. They said that the content of the PSRs were considered to be a contract between the clubs, and the provisions of the PSRs took primacy. There were loopholes in the PSRs that didn't take into account things like relegation and changing of accounting dates. So effectively, the club exercised a loophole that was entitled to do. So what's the principle here? Well, contractual interpretation is important. I think in this case, Leicester City found the loophole. They were able to apply it, and ultimately the provisions of the contract took precedence. So if we can just move on to the final slide. In terms of the takeaways, well, ultimately you need to ensure your contractual terms are clearly and precisely convey your intentions. Don't rely on vague and imprecise language. Remote possibilities and circumstances need to be thought through and accounted for, and the courts will always take primacy ultimately over what's set in the contract rather than the unwritten intentions of the parties. And that's it from me. Now I'll hand back to you, Grant.
Thank you, Andy. And thank you to all the speakers. I'm conscious of time. We're out at an hour at the moment. The new legislation to existing consumer contracts.
Yep, so the Act will not apply retrospectively, so it will only apply from the date that those particular provisions, as I mentioned, they're being brought in various phases. So from the date that those are brought into force, they will then apply to future contracts. But carefully, what they will actually apply to is any pre-existing act or omission that a business was taking. So much so that if a business then continues to be in breach of the new provisions, if you like, then they will fall foul of the Act once it comes into force. So it's very important that businesses don't take a risk-based approach and hope that the CMA will not take enforcement action, but they ensure that their consumer contracts are in compliance with the Act from the day it comes into force.
And Alison, just a quick question on CrowdStrike. So the question is, given the severity of the incident, are courts likely to adapt the way they interpret limitations of liability in contract?
It's a good question. I mean, there's a lot of commentary around the fact that this is going to be a watershed moment for the courts, and that they're going to, because of the severity of the incident, start applying a different test of reasonableness, and that if the caps are too low, they're going to kind of ride roughshod through that. And perhaps for once, they're going to challenge that presumption that businesses are big grown-up boys who can make their own deals effectively. I have to say I'm a bit suspicious of that, and we'll see. Time will tell, as they say. But I certainly think in the UK, to open the floodgates of actually getting involved in negotiations and over deciding what's reasonable and unreasonable in a contract is probably a step too far. I think the test that they've got just now is flexible enough. So we'll see. Watch the space, I think, on that one.
Okay, thank you. There's one question on AI in terms of Labour government's approach to AI. Do we think that it will go down the same route as the EU? I think my answer to that is I think it's very unlikely. I think where the government will probably go is they will look to regulate probably the equivalent of unacceptable AI, so a very high risk AI. They talked about powerful AI, not quite sure yet what that means. But I don't see the UK government going down the process of legislating in the very detailed way that the EU have gone. So don't think so, but we'll have to watch this space again. Conscious that we are over time, so I won't be able to take any more questions. Just two last points. For those of you who come to our regular data protection law updates, the next one is on the 28th of November at 12 noon. We hope to see you then. And just finally, there is a survey questionnaire. This is the first of these that we've done. We'd be particularly interested to get feedback on them so that we can hopefully take that feedback on board for the next session. So that's all from us. Thank you very much for attending, and we hope you've enjoyed listening to the speakers. Thank you.